if I believe that this is governed by the work product privilege, I'd be fine. I wouldn't require its disclosure. The issue that I have is waiver. And whether or not there's been a waiver by giving these documents to JP Morgan, who's not a party.
I just asked your opposing counsel today. I noted that there's been a long line of malfeasance on the part of Quality Loan going back to Klem and Walker, and I asked him, how is this any different? And he declined to respond.
Interesting.
Yeah, it is. Thank you, Karen.
Thank you, Chris.
Counsel, your client has a long line of malfeasance going back to Klem and Walker. How is this case any different?
I don't have any comment.
All right, thank you very much. Have a nice day.
That is 37 pages of redacted communications with JP Morgan Chase are now going in front of the judge. And I can bring a motion for waiver of privilege tomorrow.
It's terrific. I understand that they did make disclosures to third parties who are not party to the case.
Correct.
And that would be?
JP Morgan Chase.
What do you believe is in those documents?
I believe that the crime fraud exception will apply. Yeah.
So what do you think that they told JP Morgan?
I can't comment on that.
I see. I see. Of course.
Right. But here, we've got a disclosure to JP Morgan, which is not a party. So I'm questioning whether or not the joint defense privilege can apply when they're not actually a party in this case. And I don't believe the common interest privilege can apply because that's strictly deals with, in the defamation issue, when a disclosure of an otherwise defamatory comment can be privileged such that it wouldn't lead to liability and excuses that disclosure in those instances.
Okay, well maybe I've labeled it wrong, and I know that a lot of the terminology comes from her briefing as well, and some of it was an effort to address that. I think the umbrella here is the work product doctrine, and our discovery rules say that work product is privileged unless there's undue hardship. So that's kind of the umbrella objection. Obviously Chase is not a party to the suit, so it's not going to be, to the extent that the doctrine requires both parties to be requires both entities to be parties to the suit, that wouldn't apply. But I think it's, again, this is it's a work product doctrine, and it's developed. These communications are based on adjudicating the validity of the sale in this trial. And importantly, Your Honor, I know she says she can't get this information unless she goes for Quality. That's not true. She can go to the same source that Quality got its information with the discovery rules that are made available to her as a party.
Where else is she going to get these emails?
Well, these emails concern information regarding the sale, but it's between in-house counsel and these attorneys.
So I think where you're arguing now is you're dealing with whether or not I should, even though it would be covered by the work product privilege, require its disclosure because it's information that she couldn't obtain from another source.
That's correct.
Okay. And if I believe that this is governed by the work product privilege, I'd be fine. I wouldn't require its disclosure. The issue that I have is waiver. Whether or not there's been a waiver by giving these documents to JP Morgan, who's not a party. There is a case out of the District of Oregon, a federal case, where the joint defense privilege was allowed to protect disclosures between a plaintiff and a prospective co-plaintiff. So that wasn't a party yet, but the reason why it was disclosed to other parties is so that that party could consider joining the litigation. And I doubt, but I could be wrong, that the disclosure here wasn't to JP Morgan so that JP Morgan could consider naming itself as a defendant in this case. So that's my concern, is that, or not even concern, but that's what I think we need to concentrate on, is what were these documents, except they were work products, was that privilege waived by their disclosure to JP Morgan?
Well, I think we briefed it. I think work product can include communications to non-parties.
It can include communications to a non-party. So if I'm an attorney and I write down my notes of the conversation I had with a non-party, my notes are privileged. Yeah, but if I send my notes to that party and say, hey, here's my notes of the conversation we just had, I've now waived my privilege by giving them to that person that I just talked to,
Okay.
right?
Well, I think if they were both involved in the same conversation, again, it's.
And this isn't my client I'm talking about. This is a conversation with my client. This is, I'm calling up a fact witness and I want to know what they're going to testify at trial, and I write my notes and then I say, hey, here's the notes of my conversation with you. Haven't I just waived the privilege that would apply to my work product by giving them to that party?
Well, I guess our position is that it doesn't, given that they share the same common interest in defending the litigation, defending the validity of sale. And again, I'd like to go back to the point that I think is important. The information that was discussed between these parties, that same information can be obtained from the same source. But my clients, it's their attorneys that are talking about it. So if she can get the same information without attorney conversations about the litigation, that should be her route. And again, it's the
But
work
she
product.
doesn't have to if there's been a waiver.
Well,
Why
not
not
only
go
that,
the easier way?
not
right?
only that, but we have two waivers, not only the joint defense privilege, but the fact that there is now a suspicion of fraud. So the
But we're not
crime
going to, I'm not going to
exception
go
should-
there. I'm not going to go there.
Okay.
Okay. Where I am concerned that there's been a waiver is through the decision of JP Morgan, which is not a party. And I don't have anything in front of me that reveals that it's likely to be a party. So she's not asking for an absolute production. She's asking for a step short of that, which is in-camera review. And I think that's appropriate here because I think that there could well be a waiver. Now, if I review these documents and if they talk about anticipating litigation or they talk about some kind of joint defense that I think is covered, then my answer is going to be I reviewed them, I've granted your request, but I don't think these are subject to at least that discovery. And if we do that, then I might be more concerned about talking with you about the fraud waiver.
I would like to put on the record here that Mr. McIntosh stated some incorrect information because in the defendant's response brief, they claim JP Morgan Chase is beneficiary 4 times. He has just stated that Chase is the loan servicer, which they also claimed in their response. There has been no response from Mr. McIntosh regarding the 4 claimed statements in their response brief that JP Morgan Chase is the beneficiary. And in their reply...
I just want to make sure you understand.
Okay, I understand.
You just
I wanted it on the record that
Okay.
they have stated 4 times in their response that JP Morgan Chase is the beneficiary.
And I understand there's a disagreement about some critical facts in this case. And I'm not making substantive rulings today on
Okay.
who's right about what the facts are and who is the beneficiary and who is the trust.
Okay.
We're not dealing with that. You've asked me to rule on whether or not
No, I
I should do a
understand.
camera review.
I just wanted
I
that on
am
the
granting
record.
your request.
Okay, thank you.
There we go. And so there's no disrespect to you, but usually that's a good time to stop arguing.
I have one concern.
Sure.
We are noting this up for summary judgment. I guess my concern is the judge that's going to be sitting on that summary judgment viewing these materials. Is that something you've encountered in the past?
Well, on summary judgment, I'm only going to consider evidence that's before me.
Okay.
That's actually admissible evidence.